Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On the 21st of January 2025, the Media Coalition filed documents in the Idaho versus Kohberger case, this time as interested parties who wanted to be heard with respect to the hearing Judge Stephen J. Hippler set for January 21st, 2024, with just the parties, that is the state of Idaho, the defense, and Mr. Kohberger himself. This was a closed hearing to the public. The Media Coalition filed these papers because they wanted to be heard before this hearing. The court rendered an order on January 21st, 2025. This was a written order that denied the petitioners, he's calling them petitioners, motion to be heard prior to the January 21st, 2025 hearing. You can read this order if you go to the Idaho cases of judicial interest, scroll down to Idaho versus Kohberger. It is dated January 21st, 2025. And what Judge Hippler is basically saying here is that this document was untimely. It was basically dumped on his lap right before this hearing, and he exercised his discretion to deny the petitioner's motion to be heard prior to the January 21st, 2025 hearing. Attached as exhibits, the Media Coalition's filings, motion to be heard as interested parties, that's one, application for a court order. Number two, the memorandum in support of the motion to be heard as interested parties. This is where they go into the reasons why the court should grant this motion and allow them to be heard as interested parties in the case. And then finally, number three, a proposed order. They went ahead, as sometimes lawyers will do, and prepare a proposed order granting the motion to be heard as interested parties. And then we see where Judge Hippler has denied that motion. As such, the court, acting within its discretion, proceeded with the closed hearing without hearing from the Media Coalition for the reasons set forth in the order. But let's now go to the exhibits to see what the Media Coalition is saying here. First, we note that it is the same attorney, Wendy J. Olson, Anders Peterson from Stoll Rivers LLP out of Boise, that is representing the same parties. The only difference that I see here is that the lead representative of the media is American Broadcasting Companies, Inc., DBA, ABC News, and then the Associated Press. It was the Associated Press who were the lead media organization the first time the Media Coalition was heard from in this case, and this was back in 2020. So what the Media Coalition has done here is they filed a motion to be heard as interested parties, and it says, on January 15th, 2024, this court issued a notice of hearing in order regarding January 21st hearing. In that order, the court set a closed, sealed hearing to, number one, hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA. Number two, consider what portions, if any, and under what circumstances should the various motions be set to be heard on January 23rd and 24th be open to the public. This motion continues, and again, this is on behalf of the Media Coalition. While the court's order setting the Tuesday hearing unambiguously, that means clearly, close the hearing to the public and thus to the press, in parentheses, it did not make any specific findings as to the probability that the defendant's right to a fair trial would be prejudiced by having that hearing closed. Again, ladies and gentlemen, so this is the press saying, Judge, you set this as a closed hearing, but you made no findings of fact that it absolutely needed to be closed by, for instance, determining that Mr. Kohberger's right to a fair trial would be harmed if this hearing, in other words, were open. So we see the media coalition is coming out swinging, in my opinion, on behalf of the First Amendment. Nor was any member of the public or press provided an opportunity to raise objections to this closure. For the reasons set forth in the accompanying memorandum, American Broadcasting Companies, Inc., DBA, ABC News, that's the lead member of the media coalition, and all of the other media outlets that you see here through the bottom of page number 1 say that they want to be heard. They respectfully move the court for leave to present argument at or immediately before the January 21st, 2025 hearing. And then they cite to Associated Press versus 2nd Judicial District in Idaho. This is the 2023 case where the media coalition as interveners went to the Idaho Supreme Court. And you saw there that they're citing here from their own case that the Idaho Supreme Court said both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties in the defense of public access and free speech, including in Idaho. That is a direct quote from Media Coalition. Let's call the Media Coalition 1, the first time that they intervened in the case, versus 2, where they're coming back now as interested parties. They're quoting directly from the Idaho Supreme Court here. In the alternative, this means, okay, if you don't give me the one thing, I want the other. In the alternative, the interested parties request an opportunity to be heard prior to the court closing of any portion of the January 23rd or 2024 hearings to the public. So, Judge, if you're going to deny us the opportunity to be heard just prior to the closed hearing on the 21st, give us an opportunity to be heard. If you're going to close the hearing on the 23rd and 24th, these were the motions to suppress evidence that had been pending to be heard before Judge Stephen J. Hippler. Give us an opportunity to be heard at that time. And it's signed by Wendy J. Olson. She is lead counsel for the Media Coalition. Next, let's move to the memorandum of law. This is the memorandum in support of the motion to be heard as interested parties, and we're going to call this Media Coalition Part 2. This is the first time they're coming before Judge Stephen J. Hippler in this case. Introduction, they talk about who they are. They say here, the interested parties request an opportunity to present argument at or immediately before the January 21st hearing, set to be heard at 10 o'clock a.m. In the alternative, just as they said in their motion, they request an opportunity to be heard prior to the court closing of any portions of the January 23rd or 24th hearings to the public. So they're saying here, any portions, not if you intend to close all of the hearings, but any portions. And we know now that the court did decide to close the 9 a.m. portion of the hearing. So this order that was just rendered doesn't talk to this particular part of the request of the Media Coalition. They go in and they talk about who they are. National, regional, and Idaho-based news organizations and association of professional journalists that routinely cover, amongst other things, criminal proceedings in Idaho State Court and across the nation. They go on to say, this is the bottom of page 2, the interested parties have specifically investigated, reported on, and provided detailed coverage of the facts and circumstances regarding this case, including but not limited to previous pretrial proceedings conducted by this court. So some of the people involved in the Media Coalition have covered cases involving Judge Stephen J. Hippler, is what this is telling us. Additionally, going on to the next page, the interested parties, either through direct first-hand accounts or through information gained by other present press representatives, intend to report on the upcoming hearings scheduled for this week. So telling Judge Hippler, number 1, some of us have reported on your past cases. Number 2, some of us are going to report on these hearings this week on the 23rd and the 24th. On January 15th, this court issued a notice of hearing and order regarding the January 21st hearing. setting a closed sealed hearing. And you can go on over the next few pages where Ms. Olson has put together a very compelling memorandum of law in favor of the First Amendment and in favor of the press being able to do their job by reporting on this case, which has been made extraordinarily difficult, ladies and gentlemen, in my opinion, that I give again pursuant to the First Amendment, due to the extraordinary amount of information, documents, and even hearings that have been closed to the public from the beginning of the case. They put a footnote here that I think is very interesting. Page number 5. The interested parties further seek to raise their objections to the closure of the January 23rd or 24th hearings. Therefore, in the alternative, the interested parties request an opportunity to be heard prior to the closing of any part of those hearings. In other words, the Media Coalition is telling Judge Hippler, we object to any part of those hearings over those 2 days to be closed to the public, and we would like to have the opportunity to explain why. In conclusion, for the reasons set forth above, the interested parties respectfully request that the court grant its motion and allow them an opportunity to be heard prior to the closing of the January 21st hearing to the public. Signed, Wendy J. Olson and Anders Peterson, attorneys for the interested parties. Now, it will be quite interesting to see if the court will now file a second order regarding their request to be heard prior to the closing of a portion of the hearings on the 23rd. As we know, based on Judge Hippler's order that came out January 21st, he is closing that portion of the hearings on the motion to suppress, IGG, and to the extent that it relates to Mr. Kohberger's Frank's motion, that's all being closed to the public. There's going to be witness testimony for what we can deduce from the court's order that the public and therefore the press will not be able to attend. Or if the Media Coalition, as a result of not being able to attend the hearing on the 21st, and the hearings on the 23rd proceeding, part of it closed even after they raised their objections, how they may respond. If they may move to intervene again in this case and possibly even go up the chain to the Supreme Court of Idaho, because remember the first time that the interveners went to the Supreme Court originally, they were kicked back down to Latah County saying, you should have gone to Latah County first with your issues. The Idaho Supreme Court is a case, you come to us last. You don't come to us first. You go to the district court first. And then if you're not satisfied, you think you have grounds to appeal, then you appeal. Well, the Media Coalition has gone to Judge Hippler first regarding the hearing on the 21st, which was denied any opportunity for them to be heard at that time. As Judge Hippler said, it was untimely. But then there's also the issue of the hearings on the 23rd being closed to the public. We will wait and see, and if anything else develops regarding this important matter, we will, of course, report back to you. This is Kathy. Thank you very much for joining us here today.